avoid that conflict is to have a separation of these two roles.
Certainly, which also believes that there should be a separation in these two functions, that the system doesn't really work satisfactorily as it is. So it's not the case that we have this perfect system at the moment, and that an improvement should be made really through the separation of these functions in terms of public perception at the very least.
In your written evidence, you've made reference to that. Do you want to add anything to what's included in that written evidence?
Well, obviously, what's being proposed with the regulatory committee and the lay majority and lay chair is good news, is progress. We still feel that there should be a complete separation, but if there can't be a complete separation in Scotland, then I think that's certainly the way forward. We also feel that the advisory committee that's being proposed should be a statutory committee. It's very important that we have that pool from really from outside the legal profession, if you will, to advise the government on future regulation on this. So we certainly do feel that that should have a lay majority and a lay chair also, and should be a statutory body. Because, of course, what's proposed at the moment is that the government will regulate the regulators, which is not an ideal position at all, I think. But if that is what's going to happen, it's very important we have a very strong advisory body.
Thank you. Could I ask what advantages for consumers would arise from having more than one approved regulator for licensed providers, and what would be the benefit of regulatory competition?
Well, competition should normally always have benefits for consumers, unless there's a particular market where there's best only to have one provider. Our position is that, as regards approved regulators, they have a very important role to perform in the way they license, and that if the actual LLSPs, if there's a demand for a choice of approved regulator, then that will hopefully also develop the number of LLSPs coming through, who can then, there'll be more of these firms available for consumers to choose from.
Just Julia was going to say something else.
No, really, I was going to reiterate that, so I won't take your time.
Fine, we'll go to Robert Brand.
Thank you, Ash Convener. I wanted to ask, Scotland's a different size of jurisdiction to England, to the tune of 1/10 and all of that. I wondered what your view was of the submission by the Institute of Chartered Accountants that basically indicates you could get some of the advantages of a wider choice, one-stop shops and all that by an extension of the system under which they operate, under which they can approve a solicitor to be a principal in a firm of a chartered accountants. And they suggest that might be applied to the Law Society, if you like, in reverse, and to adapt a sort of much less bureaucratic-sounding model, if you like, appropriate, they would argue, I guess, to the Scottish circumstances. Have you a view about that? Can you achieve the same objectives by that sort of approach?
I wondered how many solicitors had taken that route with ICAS. If it's available.
No idea.
I mean,
I think the model that ICAS works to has certainly been on the table in the discussions that have taken place so far that have led to the bill that's before you. And my own understanding is that it was considered, frankly, as somewhat too radical and a much greater step and departure from the existing arrangements than is the case. I think from the point of view of the OFT, we would certainly not discount that sort of simple arrangement. If you can build in adequate consumer protection, then something that's unbureaucratic and so on is obviously preferable.
You can see lots of kind of similarities, if you like, in terms of tax advice and certain things to do with divorce and all of that, where there's a coalescence of interest there, where the one-stop shop might have perhaps greater provenance than the critical comments I made about surveyors earlier on. Yes, thank you.
There's one sweeping up question here. I take it, Ms Aspinall, that your position today is the same as it has always been throughout the procedure, because I note that when you gave evidence at the Legal Services Bill reference group, you were quite specific that the regulation plan you actually would have approved would be the adoption of a separate regulatory committee.
The Law Society of Scotland?
Yes.
Yes. Well, I think their proposals do amount to a separate regulatory committee in all but, I mean, there just isn't the name change that goes with it, as in England and Wales.
We're quite happy with that.
Well, I think, as I said, I think the preference would be to have sort of a clear indication that there is separation. So they have the separate regulatory committee, but how will that be perceived externally by consumers? Will they be aware that there's a separate regulatory committee?
Right. Okay. Thank you, Nigel Dawn.
Thank you very much, Convener, and good morning again, ladies. Given that 3 of the 4 complaints, grounds of the complaint, super complaint by which related to advocates, are you happy with the bill as it stands?
Well, no, we feel that the advocates should clearly be taken into this bill. We see no reason for a bit of legal services to be hived off and frankly not allowed to modernise. So we're not happy with that part of it, no.
Can I pursue that before I get to the OFT? Can I pursue that to say, to ask in what way you would like them to modernise, or perhaps more fairly, what you would like the result of that modernisation to be?
Well, we'd like them to be able to form ABSs, you know, to form firms with lawyers, with other professionals. We'd like consumers to be able to commission an advocate directly, which is usually not the case still. We'd like them to be able to work in different, more modern ways, more accessible, transparent ways, and would like their regulation and representation to be separated too, so the public could have more confidence in that.
What do you hope to achieve by that, though, please?
A more modern, user-friendly legal services industry in Scotland, where people knew what they were paying for, had a competitive market to get the best price for that, and to understand more about the legal services process they're using, I suppose.
What expectation do you have that the consumer, the man in the street who is not in this room, could choose between advocates?
I'm not saying that everybody would want to choose their own advocate, but some consumers are highly educated and informed and are capable of that, and they should be able to do that, I think.
Is that 0.5% of the population not able to work through a solicitor to get the right advocate at the moment?
Well, why do they have to pay a solicitor if they don't have to? You know, I do accept it. We're not talking about the majority of people will want to rush off and commission their own advocates. I do appreciate that. But for the people that do, it's an indication of how the service is set up sometimes, not always to offer choice to the consumer at the moment.
Would it not be fair, though, that if I've guessed my numbers correctly, and they have at least made the point, that the 99.5% of the population who would have no idea how to choose an advocate, because apart from anything else they wouldn't know the language in which to discuss the subject before them, if it makes sense for them to go to a solicitor to work out the language, to work out what the issue is, for the solicitor to sort out who the barrister should be for 99.5% of the cases, then isn't the system pretty good at the moment?
We're not trying to say that it's not working for the majority of people, but the bigger point really is that the advocates will not be joining in ABS arrangements under this bill. They'll not be taken into the arrangements. There's still not a clear separation of regulation and representation in the faculty of advocates. And I think that is something that should be corrected in the bill, and won't be, unfortunately.
Can I forgive me, I'm hoping the other ladies will answer these questions in a moment, but can I just pursue this, please, Julia?
Sorry.
I'm told there are 460 advocates practising in Scotland. That's a pretty small bunch of, we accept, very professional, highly qualified people. do we really need a complicated structure for the regulation of 460 people who are themselves regulated by the court